It is illegal to discriminate against a job applicant or an employee because of their race, color, or national origin, religion, sex, gender identity, or sexual orientation, age or disability, or genetic information. It is also illegal to retaliate against any complaints made by an employee or job applicant. Sexual harassment is any unwelcome, verbal, visual, or physical conduct of a sexual nature that is severe or pervasive and affects working conditions or creates a hostile work environment. Verbal or written sexual harassment is probably the most obvious and most common form of sexual harassment. Examples may include offensive jokes or compliments of a sexual nature or sexist nature, repeated and unwelcome requests for sexual favors, repeated and unwelcome requests for dates, excessive and unwelcome flirting, or threats regarding adverse employment if sexual favors are not granted. Physical sexual harassment is harder to recognize because it can be subtle. Physical harassment in relation to sexual harassment is when a victim is inappropriately touched. Most importantly, the victim is touched against his or her will. Examples of physical sexual harassment may include massaging a person on any body part without asking for permission, playing with a person's hair, caressing a person's arm, hand, or any body part in a sexual way, making bodily contact with another person in a sexual way, cornering a victim with one's body, lewd hand gestures or other gestures meant to convey curse words, unwanted touching of a person or their clothing, frequently following or standing too close to a person on purpose, making sexually suggestive facial expressions, or playing music with offensive or degrading language. Visual sexual harassment is hard to spot because it's the most subjective and requires you to put yourself in the shoes of the reasonable person. Examples may include wearing clothing with offensive or vulgar language, displaying posters or pictures of a sexual nature, showing other people sexually suggestive text messages or emails, or drawing violent or derogatory images. A quid pro quo sexual harassment claim is when an employer suggests making employment decisions affecting an individual based on the individual's response to the employer's unwelcome sexual conduct. The offer may be expressed or implied. It is helpful for the victim to inform the harasser directly that the conduct is unwelcome and must stop. The victim should use any employer complaint mechanism or grievance system available. Remember, it is illegal to retaliate against a person because they complained about discrimination, filed a charge of discrimination, or participated in an employment discrimination investigation or lawsuit. The administrative rules describe a hostile work environment as any unwelcome verbal or physical conduct that is sufficiently severe or pervasive to have the purpose or effect of unreasonably interfering with work performance or creating an intimidating, hostile, or offensive working environment. It can also be a work atmosphere in which a pattern of offensive sexual conduct is involved, such as when one party interferes with the work performance of the victim in an unreasonable manner, intentionally leaves the victim in an intimidated or hostile work environment, or exposes the victim to a rude, lewd, and uncomfortable work environment. The conduct can include verbal, nonverbal, visual, or physical. You do not need to be a direct victim to file a complaint or sue. Some things to consider include the nature of the conduct, the frequency of the conduct, the period over which it occurred, whether the conduct was physically threatening or humiliating, and the extent to which the conduct unreasonably interfered with an employee's work performance. Courts will determine whether a hostile environment harassment claim is valid based on the following elements: whether the conduct was verbal, physical, or both, frequency of the conduct, whether the conduct was hostile or blatantly offensive, whether the alleged harasser was a coworker or manager, whether others joined in perpetrating the harassment, and whether the harassment was directed at more than one individual or singled out the victim. There are many forms of abuse in the workplace. Let's look at many things we need to be aware of. Sex is assigned at birth based on the physical reproductive system a person is born with. Gender identity is a gender a person identifies. And sexual orientation is a person's identity in relation to the gender or genders to which they are sexually attracted to. A person's gender preference may differ from the sex assigned at birth. Abusive conduct is conduct in the workplace that a reasonable person would find hostile, offensive, and unrelated to an employer's legitimate business interests. Examples can include repeated infliction of verbal abuse, such as the use of derogatory remarks, insults, and epithets, verbal or physical conduct that a reasonable person would find threatening, intimidating, or humiliating, or the gratuitous sabotage or undermining of a person's work performance. A single act shall not constitute abusive conduct unless especially severe or egregious. If you are the target of rude, bullying, or illegal behavior, speak out. Do not ignore rude or bullying behavior. Calmly speak to the offensive coworker or speak with your supervisor, and explain how the offensive behavior needs to stop. If you witness unacceptable or illegal behavior happening to someone else in the workplace, distract, change the subject, try to strike up a new topic of conversation that is work appropriate. Direct conversation. Talk to the harasser yourself and share your perspective. Support. After the conversation is over, talk to the targeted coworker and offer support. Document what happened, and report. Report the situation to your supervisor, Equal Employment Office, or HR director. Tangible employment action happens when unwelcome conduct from a supervisor or someone with supervisory authority results in significant changes in the conditions of your employment. Tangible employment action may include denial of overtime, discipline, promotion, or termination. A tangible employment action can be a type of retaliation. Taking formal action is an option when responding to harassment. This can include the following: tell your supervisor or file a formal complaint with your employer, filing a formal complaint or charge with the Equal Employment Opportunity Commission or the EEOC, federal, and file a private lawsuit. When you tell your supervisor or file a complaint with your employer, the supervisor is required to investigate the allegations. The supervisor cannot guarantee confidentiality, and they must also inform their manager and/or HR. When filing a formal complaint with your employer, a formal investigation will occur. They will conduct thorough interviews with the complaining party, the accused party, and any relevant witnesses. When filing a formal charge or complaint with the EEOC, the following will occur. Claimants will meet with an intake investigator who asks questions about facts of the alleged discrimination, and the EEOC will notify the employer of the charge. The EEOC will then offer a mediation option. Mediation is often fast with a high success rate for both parties, and if mediation is declined or fails, the EEOC will investigate. EEOC investigators will ask the claimant for evidence, interview witnesses, and obtain a position statement from the employer. Investigations can take a long time. When the investigation concludes, the EEOC issues a letter of determination on whether discrimination is more likely to have occurred than not occurred. When the investigation concludes, the EEOC issues a letter of determination on whether discrimination is more likely to have occurred than not occurred. If likely discrimination is found, the EEOC must attempt conciliation. Conciliation attempts to resolve the discrimination through policy changes to prevent ongoing discrimination and preventing litigation, which is the next legal step. If conciliation fails, either the EEOC can sue or can issue a right to sue letter to the individual so the claimant can sue. An individual must complete the EEOC process before suing. Note, if the EEOC sues, the litigation is in the public interest to prevent future discrimination. In harassment cases, you must file your charge within 180 or 300 days of the last incident of harassment, although the EEOC will look at all incidents of harassment when investigating your charge, even if the earlier incidents happened more than 180 to 300 days earlier. A job discrimination complaint may be filed by mail or in person at the nearest EEOC office. Find the closest EEOC office by calling the EEOC at 1-800-669-4000. The map on this slide shows the EEOC's field offices for each district. To file a job discrimination complaint, it is helpful to have the following information: the name, address, and telephone number of the person who is being treated unfairly, the name, address, and telephone number of the employer you are filing the complaint against, a brief description of the event or events that you believe are unfair or harassing, and the dates these events occurred. If you believe you have been treated unfairly or harassed at work by a federal government employer, you must follow different procedures. For information on how the process works, you should see the guidelines for federal sector equal employment opportunity complete processing. Retaliation is punishing someone speaking up about sexual harassment or other forms of discrimination or harassment. Any retaliation is against the law. Retaliation can happen after someone opposes or participates in an investigation in sexual harassment or reports or files complaints of sexual harassment. Retaliation includes things such as changes in assignments, failing to communicate, being subject to gossip, and demotions or threats. It is unlawful for employers to fail to take all reasonable steps to prevent discrimination, harassment, and retaliation. Some factors may be unique to the employer. These factors can include workforce size, budget, and nature of the business, and facts of the case. Employees should be able to expect investigation of all sexual harassment complaints brought to your employer's attention and without retaliation. In this training, we have discussed the following topics: introduction, hostile work environment, other types of harassment, and preventing and responding to sexual harassment.